Today we will talk about standing. Before a lawsuit can proceed through the courts, we have to make some initial findings. One, that jurisdiction is proper. Jurisdiction looks at the authority of the court and can it hear this type of case. It also looks at whether the court has authority over these parties. Next is venue, which looks at the geographic location of the trial. And then we look at standing, which asks, is this a proper party to bring this case? These are said to be matters of justiciability. And that relates to Article 3 of the U.S. Constitution, which sets up our judicial branch. The judicial branch is given powers over cases and controversies. Remember, we divide up the different powers among the branches, and the courts get to hear cases and controversies. And so part of that is deciding whether the person bringing the lawsuit, the plaintiff, has standing. To decide if a party has standing, the court looks at three things. First, the court looks at harm, injury. The party bringing the lawsuit must have suffered a harm, or it must be imminent. A hypothetical possibility of a harm in the future cannot provide the basis for standing. This harm can be economic, it can be physical. Next is causation. There must be a traceable link between the challenged act and the harm or injury. And then lastly is the issue of redressability. This means, is the lawsuit, if successful, going to remedy the problem the plaintiff complains of? This explanation of federal standing law is laid out more precisely in Lujan v. Defenders of Wildlife, a 1992 opinion from the U.S. Supreme Court.